application in the matter of Valbonne Estates Ltd and Cityvalue Estates Ltd and another.
Yes, Mr. Baker.
May it please my lords and my lady, I appear on behalf of the appellant
Yes.
this morning. Mr. Newman appears on behalf of the first respondent, and Mr. Levy on behalf of the
Yes.
second respondent. My lord, there are a few minor housekeeping matters that need to be dealt with
Right.
first thing before I actually start the substance of the appeal itself. Firstly, permission for the appellant's supplement skeleton to be read and used.
Yes, we've read all the skeletons.
I'm very grateful. I had believed that my lord had given permission, but I
Yes.
just wanted to just double check that.
We've read all the skeletons, and we've read the judge's judgment and the note of Mr. Justice Mann's decision.
Yes, thank you very much. Secondly, there is some additional documentation to go at the back of the bundle, which just takes matters slightly over the 350-page limit in the supplemental.
Why is it necessary?
It's necessary, my lord, because it goes to an issue regarding completion, which was raised before the...
Why does completion matter? The fact is that the TR1's been signed, it's been lodged at the Land Registry, it was lodged on the 10th of December.
Yes, my lord.
Which, as it happens, is the date on which Mr. Justice Mann made his order. The order that he made prohibited lodging the TR1, but that's now been done. There's been no application to vary the order to require the purchaser to withdraw the application for registration. So why does completion matter?
Well, completion matters. My lord will see what I've said about that, and also what I say in terms of the substantive claim against the second respondent, that completion as to whether what my client has not received is any clear answer as to A, why there was a lower purchase price agreed from the price in the auction, and secondly, whether the actual sums in terms of the purchase monies were ever paid over. And that is raised in that recent correspondence.
Well, that may be so, but I can't see why it matters in terms of the order that you sought.
Well, my lord, I'm not going to labour the point in terms of, because it is only a relatively minor issue as to whether those additional documents should be read or not, and I'd rather that we deal with the substance of the actual appeal.
Just before you start, Mr. Baker, if I may say so, your skeleton argument goes a long way beyond the grounds for which you have permission to appeal, and you will have to confine your oral submissions to those parts of the judgment against which you have permission.
My lord, do you mean the original skeleton? Because the original skeleton was prepared for permission to appeal.
Well, I have something which I think was called replacement. At least what has been put in my bundle as the replacement seems to be pretty much the same as the original skeleton.
It was, my lord, and the reason was simply just to, rather than have to carry out further work and increase costs.
Yes.
It was just simply, I was going to explain orally, my lord, that of course the section that deals with matters that Lord Justice Arnold did not give permission on are clearly not material to this court's decision.
Well, fine. Well, we have in fact read the whole skeleton.
Yes.
But I'm just saying that it goes
my
beyond the grounds.
Quite, and I wouldn't seek to
no, that's fine. All right.
deal with those matters because I don't have permission for them.
No.
Yeah.
Right.
My lord, can I just deal...
I'm sorry.
Yes, my lady.
Sorry to interrupt. Just so that I'm certain, could you give me the date of the skeleton upon which you are relying?
It should still be dated the 31st of March.
Yes, mine.
Thank
That
you.
was the
Yeah, I'm just checking.
Yes.
Thank you.
Yes.
But is it called something other than skeleton submissions on behalf of the appellant?
Sorry, my lord.
Skeleton submissions on behalf
Yes,
of the appellant.
that's the document. My
That's
lord.
the document,
That's
and
the
it
document.
runs to...
And then there should be a second one, further skeleton submissions, and that is dated the 4th of June.
Yes.
Yes. Now, my lord, in terms of timetabling, there has been a little discussion between the advocates as to dividing the day. Lord Justice Arnold originally gave it a half a day timetable, but it was at the respondent's request extended to 1 day. I will complete my submissions by 12:45. That will then allow the first and second respondents to have until 4 o'clock, and then the 4 to 4:15 in terms of any response that I shall make to their submission.
Well, I think we'd like to hear the argument on your appeal
Yes.
before we deal with any of the questions raised by respondents' notices.
Very well, then I will tailor that because accordingly.
Yeah.
So, my lords and my lady, I am conscious that the grant of permission by Lord Justice Arnold and the focus of this appeal is on the issue of reimposition of an injunction.
Yes.
In order to save costs, as I've already explained, that is why I was using the original skeleton submissions, which certainly were not intended to confuse the court on
All right,
that.
I understand.
In terms of grounds, if we turn to the core appeal bundle, and we see the grounds are set out at tab 3, the only grounds that I have been given permission to deal with are 16 to 26.
Yes.
The first 7 pages of my original skeleton submissions, I do say, are still relevant because they deal with the factual background, and then it's pages 15 to 24.
Yeah.
So in these submissions, what I'm going to deal with is the following. And I was going to split these into 3 parts and deal finally, thirdly, with the response notice, but in the light of Lord Justice Lewison's comments, I shall not be dealing with that now. So there are 2 aspects to my submissions. Firstly, the policy and the principles behind reimposition. In so doing, I'm going to look at and examine some of the case law and deal with the wider principles concerning the penal nature of the sanction where there has been material non-disclosure. And then secondly, after having dealt with that, I shall deal with the application of those principles to the facts in this particular case, and why I say the learned judge failed to reach the correct conclusion and failed to take into account a series of material factors that were central both in law and fact to the decision-making process regarding reimposition. So let me turn firstly, and in so doing, my lords and my lady, there are 2 bundles in terms of the authorities bundle. It's the larger first one that I shall really in the main be turning to. It's the books and learning that's in file number 2.
Sorry, just before we go to all the other authorities, the judge sets out what she considers to be the law, paragraph 28 to 32, and she deals with the discretion to continue or re-grant the order at 66. Is there anything wrong, do you say, with her formulation of the law?
I do, my lord, and
Right.
I'm going to develop that as I go along, but it is necessary for me to develop the strands of
I follow.
of-
So does it follow from that you say that Mrs. Justice Carr was also wrong?
No,
You don't?
no, I don't, my lord, because what I say is that in Tugashev, she has adopted, and again, I will need to develop the jurisprudential line of authorities and how the thought has gone on this issue. But no, because what I do say is that there are principles that underpin the imposition of sanctions in this type of situation. And what I do say is that Mrs. Justice Bacon did not correctly adopt those principles, albeit she does refer to Tukashev, but I say, and then again, I will need to develop this.
No, I'm sorry, I'm not quite following. Are you saying that she incorrectly stated the principles, or are you saying that she correctly stated the principles but misapplied them?
I say that the principles were not set out fully enough. So again, when I develop this argument in terms of principle, I do say that the principles are fuller than she has set out, and she has misapplied them.
Can you show me where in the skeleton argument you developed this argument? I wasn't able to detect from it any criticism of the judge's formulation of the law.
Well, I do say that, my lord, and we see that at paragraphs, again, this is really from paragraph 67.
57, did you say?
67. 67 and 68.
Yes. Where do you say the judge was wrong in what she said at 28 and 29 of her judgment?
Well, 28, 29, my lord, really very much deals with the principle of discharge, which isn't material to this to this appeal. The focus of my submissions is all about the imposition.
Hang on, you say that, but 29, Roman 2 and Roman 3
yes,
do deal with reimposition.
yes, but they are then dealt with much more fully when she applies the principles towards the end of the judgment. But my lord, I do say that I have dealt with those points, and they're dealt with certainly at 67, and then particularly in relation to the case of the Ugrineft case and the judgment of Mr. Justice Christopher Clark, as he then was. But I am going to develop those during the course of this morning. The starting point, my lord, in the development of the principles in my submission is the authority of Brinks-Matt, which is at tab 4 of the bundle. Now, this case concerned the well-known gold bullion robbery, and an injunction was obtained without notice restraining disposal of certain assets. The order was set aside on the basis of material non-disclosure. The Court of Appeal then reimposed the injunction, saying that it was a proper case where an injunction should be maintained. If we turn to the judgment of Lord Justice Balcombe at 1358, please, and I'm looking between C and D, that paragraph there. And there is a twofold purpose. My lords and my lady, if one reads down from between C and D through to F, what Lord Justice Balcombe says is that there are two purposes. The first purpose is to deprive the wrongdoer of an advantage improperly obtained. Now, I should also deal later on in these submissions whether there really was an advantage that could be said to have been improperly obtained in this particular case. And then secondly, at D, he refers to the fact that it must serve as a deterrent. And again, I shall be dealing with the deterrent effect.
Yeah, so that's what the judge says at 29 Roman 1.
Yeah, well,
Nothing wrong with that then?
my lord, again, I'm going to particularly focus on some of the later authorities as this principle is developed.
All right.
And so it isn't perhaps necessarily quite as stark as just those two stages. Now he says that it must not be allowed to become an instrument of injustice. It has to be used sparingly, but it's not defined or limited in any way. Turning over the page, Lord Justice Slade, between B and C, says, nevertheless, the nature of the principle, as I see it, is essentially penal, and in its application, the practical realities of any case before the court cannot be overlooked. So again, I'm going to develop, during the course of these submissions, what is really meant by penal here, what is the court punishing, and how should it best decide what that punishment or, in effect, sentence should actually be. The second authority, which I do say is of particular importance, is a case at tab 9, one I've just referred to before, Ugrinev, a decision of Mr. Justice Christopher Clark, as he then was. That case concerned the appointment of a provisional liquidator, and there was material non-disclosure. It's set out at paragraph 101. A series, and in my submission...
I'm having some trouble with the connection. Please try again in a moment.
I'm sorry?
Sorry, that wasn't me. My lord, it was, I think someone's computer.
I do apologise, my computer was speaking.
Oh. Right.
So, my lord, we were at 101.
Yes.
And there, the judge summarises what the non-disclosure was. There was a failure to disclose evidence about Mr. Abramovich's evidence in BVI proceedings about his residence. The facts that are set out in paragraph 94 were incorrect, and also the matters set out in paragraph 96. One can refer back to that. It's the principles that I want to focus upon. Now, the judge then, at 102, starts to deal with that particular issue. And he refers to a decision of Mr. Alan Boyle, Queen's Counsel, as sitting as a deputy judge of the Chancery Division, the Arena Corporation and Schroeder. And those principles that he sets out there are a useful, in my submission, guide to the way the matter should be considered. So firstly, the general rule is that it should discharge the order in breach and refuse to renew under a trial, but notwithstanding that, the court has jurisdiction to continue or re-grant the order. It should be used sparingly at number 3. At number 4, the court has to assess the degree and the extent of culpability. So there is no rule that even a deliberate breach will actually attract the sanction of discharge and failure to reimpose, and equally an innocent breach may well do. Then the court has to assess the importance and the significance to the outcome, and I shall deal with those principles later on in my second section. Then weighing the merits of the claimant's case, but that shouldn't in itself undermine the policy objectives, presumably the policy of the deterrent. Then the principle should not be used as an instrument of injustice. The jurisdiction is penal in nature, and the court should have regard to proportionality. And then finally, there are no hard, fast rules. The court should take into account all relevant circumstances. Now, if one turns on to 103, as in my submission, Mr. Justice Christopher Clark takes matters a little further, because then at the end of that paragraph, he says he regards that as a helpful review. And then he says, in exercising that discretion, the court, like Janus, looks both backwards and forwards. And at the heart of my submission this morning is that the judge overly focused on looking back, and the culpability and the principles and the concern which the judge had about my client's behaviour, which my client has to accept and hasn't got permission to appeal on anyway, that there was a heavy focus on looking back and a very limited focus on looking forward. That's 103.
Can I just understand what you mean by limited focus?
Yes, my lord.
Are you saying that she failed to take into account things she ought to have taken into account?
Yes.
Or are you saying she gave too much weight to the look backwards as opposed to the look forwards?
I say both, actually.
Both.
She
Right, so just to break that into two stages.
Yes.
If she failed to take into account something which was legally relevant, which she ought to have taken into account, then that is a ground on which an appeal court can interfere with the exercise of discretion. If, on the other hand, she placed too much weight on looking backwards as opposed to looking forwards, you would have to surmount the hurdle of persuading us that no reasonable judge could have exercised the discretion in the way that she did.
Well, I say both, my lord. And I say on the first, she hasn't gone through all the correct considerations when and effectively examining what the appropriate penalty should be for my client in this particular situation.
Yeah.
So that is the first thing. The second aspect, my lord, in answer to your question, is I do say that in this particular situation, if one's looking at weighing it in terms of almost a metaphorical scale, the looking back so outweighs the looking forward that it tips matters beyond those bounds in terms of discretion. So I would say that on both aspects, my client can succeed on this appeal. Back to Mr. Justice Christopher Clark's judgment at 104. He refers there in the third line of 104, the obligation of full disclosure, an obligation owed to the court itself, exists in order to secure the integrity of the court's process and to protect the interests of those potentially affected by whatever order the court is invited to make. And then at 105, yes, of course, the court's ability to set its order aside, to refuse to renew it, is the sanction by which that obligation is enforced, and others are deterred from breaking it. Such is the importance of that duty that in the event of any substantial breach, the court is strongly inclined towards setting its order aside and not renewing it, so as to deprive the defaulting party of any advantage the order may have given him. This is particularly so in the case of freezing and seizure orders. What I do say, just looking at those final few words, this is not a case of a freezing injunction. We were talking about a proprietary injunction to prevent registration or sale or registration of a particular property. So it's not quite in the territory of the freezing or the seizure order. Moving on to 105, my lords, my lady. As to the future, the court may well be faced with a situation in which, in the light of all the material to hand after the non-disclosures become apparent, there remains a case, possibly a strong case, for continuing or regranting the relief sought. Whilst a strong case can never justify non-disclosure, the court will not be blind to the fact that a refusal to continue or renew an order may work a real injustice, which it may wish to avoid. And then finally, in terms of this authority, 106. As with all discretionary considerations, much depends on the facts. The more serious or culpable the non-disclosure, the more likely the court is to set its order aside and not renew it, however prejudicial the consequences. The stronger the case for the order sought, the less serious or culpable the non-disclosure, the more likely it is the court may be persuaded to continue or grant the order originally obtained. In complicated cases, it may be just to allow some margin of error. It's often easier to spot what should have been disclosed in retrospect and after argument from those alleging non-disclosure than it was at the time when the question of disclosure first arose. And I just pause there, and that's with those principles. And I say I'm going to just develop this a bit further before I turn then to the actual facts. Now I now turn to Tugashev and Mrs. Justice Carr, as she then was, and that is at tab 15 towards the back of this bundle.
No.
Not in my copy. I think it must be in the next bundle.
Oh, well, I haven't got it in
I'm
this
sorry, are we looking at different bundles?
one.
No, it's at the second tab in the second bundle of authorities.
It might have been collated slightly differently, so I do have it at the back of the first one.
Number 15, my lord. And what I'd like to report, again, I'm not going to do, the law is set out at paragraph 7.
Paragraph what?
Paragraph 7, my lord.
7.
But I would like you to turn to Roman 10, please.
Roman 10.
Yeah.
Yeah.
So again, there she says, whether or not disclosure was innocent is an important consideration, but not necessarily decisive. Immediate discharge is likely to be the court's starting point, at least when the failure is substantial or deliberate. It's been said on more than one occasion it will only be in exceptional circumstances. In case of deliberate non-disclosure, the order would not be discharged.
And that is what is repeated by the judge in this case.
I accept that, my lady, but what she does not do, as I say, is refer back to those principles that Miss Justice Christopher Clark referred to, and the way he set the matter out, and went through that stage by stage.
What is the point that she fails to acknowledge
Well,
in that and the following paragraphs?
in Tugashev?
Oh.
Well, my lord, these are different ways of course, what I say in Tugashev, and again, perhaps if I can just develop the point, my lord, what I'm not criticising this judgment. What I'm criticising is the judgment below, in this case, and the way the judge applied the principles by, as I said to Lord Justice Lewison, by overly looking back rather than looking forward. Now, I'm not suggesting that the principles...
I'm sorry, Mr. Baker, I'm getting confused again. I did ask you earlier on.
Yes, my lord.
Were you saying that the judge, Mrs. Justice Bacon,
Yes.
misstated the principles or correctly stated the principles but misapplied them? Now, a few seconds ago, you were saying that she misapplied them.
Yes.
That I understand. But are you also saying she misstated them? Because I can't see it in your skeleton argument.
What I say, my lord, is that she misapplied them, but I say that in terms of the stages that need to be, she misstated them in the sense that she didn't look at the principles in the way that other judges set out that the way those principles should be adopted. And that Tugashev, whilst I accept she refers to Tugashev, and I have to accept that what she doesn't do is look at it in a broader way. She makes that reference to Tugashev, but she didn't look at the way other judges had dealt with the matter, even though those authorities were presented to her. So she had them available. But
So what aspect of, for example, Mr. Justice Christopher Clark's formulation does it fails to be reflected in what Mrs. Justice Bacon found in Tugashev. You've shown us
Yes.
paragraph Roman 10,
Yes.
and she goes on 11 to refer to the penal approach, and at 12 to refer to the discretion to continue or reimpose in the interests of justice.
Yes, she does. What I say is
13 to the fact that failure of disclosure may be marked in some other way, for example, by costs. So what's missing?
what is missing? Well, my lord, again, perhaps I can just come back to that, because as they say, as I'm going to develop this, but what I say is missing is particularly the focus of the focus, the way she applies the balance between looking back and assessing culpability and then the potential sanction.
So that's the application of the principles, not the statement of the principles.
Well, as I say, my principle is that the way she applies it is incorrect.
Yeah.
But I do say that she could have
So,
set out...
which she are you talking about? Mrs. Justice Carr or?
No, Mrs. Justice Bacon
Mrs. Justice Bacon.
could have set out matters far more clearly, because she deals with the... And again, I'm slightly preempting what I'm about to say in terms of the application, further application of the principles and the facts, to the way she actually adopts matters. There could have been greater clarity rather than just simply relying on Tugashev.
It doesn't seem to me that you've pinpointed any error in the test which Mrs. Justice Bacon applied, but what you're concerned about is the application of the principles and the fact that you say, and this is just my summary, it may be wrong, Mr. Baker, but I'm just trying to summarise where I think you are, that you're saying that Mrs. Justice Bacon put too great an emphasis on previous conduct and not enough emphasis on the position going forwards, and therefore her balance of those things when she was looking at whether there was an injustice was wrong. Is that just
that is
it in a nutshell?
That is absolutely.
Yeah. All right. I think we've understood that. It perhaps also is worth pointing out that in paragraph 29 of her judgment,
Yes.
Mrs. Justice Bacon says the propositions set out by Mrs. Justice Carr are not contentious, and I do not need to repeat them here. So that seems to have been common ground below, that Mrs. Justice Carr's summary was enough.
They're not contentious, but whether I'm not prepared to accept in my submission that they were enough, because of course what was put before the court was a wider range of cases, including the ones that I've already referred to, my lord, and the ones that I'm going to refer to, because there's, I think, one more that I want the court to examine.
It is clear, in the light of what my lord has drawn attention to,
Yes.
that Mrs. Justice Bacon had fully in mind the whole of what Mrs. Justice Carr said in paragraph 7, and she must be taken to have intended, at any rate, to apply those principles. Whether she did so correctly is a matter for your submission.
Yes, I would be prepared to accept that, my lord. As I say, that must be correct. Mm-hmm. What I do say is that when then looking on that second point about the application of the principles and the facts to the principles, if one then turns to Roman 12 and the interests of justice and again looking at those principles, and then particularly in Roman 13, what she says there, and the final sentence, that the court has at its disposal a range of options in the event of non-disclosure. What I do say is that in Tugashev, if one looks at paragraph 17, where she sets out some basic facts in relation to non-disclosure, there was an issue about shareholdings and whether Mr. Tugashev had divested himself of shares. He deliberately withheld documents that would have been disclosed at an on-notice hearing. He denied any merit in Mr. Orlov's position and refused to research the events in question. And what I do say is that in this case, again, I will develop this in my second part of my submissions, is that Mr. Silva, in his second witness statement, gave a thoroughly detailed explanation as to how the errors came about, albeit, and I do accept that the court still found that they were material matters that should have been disclosed to the court. Finally, Francis and Al-Assad.
Before you go
Yes,
there,
my lady.
you referred us to little 13
Yes.
of paragraph 7 in Mrs. Justice Carr's judgment, and particularly to that last sentence,
Yes.
that there is at the court's disposal a range of options. But that surely is taking you into territory of the exercise of discretion, and you have to surmount the hurdle of no reasonable judge could have decided in this way, or this is outside the generous ambit of discretion, etc. Do you not?
Well, as I say, my lady, when I, to Lord Justice Lewison's question 15 minutes ago, and I said that when one balances those scales, here, in my submission, there was a very clear exercise in terms of almost a sentencing guideline that Mr. Justice Christopher Clark sets out, that one can go through and look at each point and weigh up very clearly what the appropriate penalty is. And what I say is that the very clear approach that he has set out wasn't actually adopted, because there was so much focus on culpability that my client wasn't even effectively given an opportunity to, and so much looking back, that there was no opportunity to really look forward. And that's why I say it takes...
Sorry.
No, my lady, that's why I say it takes it outside that generous ambit.
Mr. Justice Christopher Clark would have discharged the injunction, he says, had he not struck out the claim.
In those in the facts of that case, yes. Well, again, that's ultimately in my submission not relevant to this particular case.
But you are saying, are you, in effect, that Mr. Justice Christopher Clark laid down in effect, a process which any judge has to go through in deciding whether or not to reimpose an injunction or to take some other course in relation to culpable non-disclosure?
Well, I'm not suggesting, my lord, that it's a mandatory requirement for judges. What I'm saying is that it's a paradigm example.
Well, if it's not a mandatory requirement for judges, what was the judge's error? This judge's error, Mrs. Justice Bacon's error in not following it.
Well, the judge's error is that in Ugraneff, a very clear precedent and example of how a judge should go about this exercise is set out.
One possible way of doing it.
Well, but I suggest...
Well, it's either one possible way of doing it, or it is the necessary way of doing it. But you can't say the latter, can you?
No,
Perhaps you do?
No, I'm not going to suggest that, my lord. But what I do...
So it's one possible way of doing it.
But
Maybe a good way of doing it.
And
depending on the facts.
And, my lord, if one doesn't adopt that good way of doing it, then I submit that a judge potentially, if they don't adopt those particular tests, they can fall into error. And that's what I say has happened here. And that again, as I say, in answer to Lady Justice Asplin's question, I say it does fall outside the ambit of discretion here. Because, and so if we move on to Francis and Al-Assad, that's at tab 8.
Sorry,
That's
tab which?
8.
8.
8 in my bundle, my lord. I hope it is in everybody else's.
Yes.
So, just before we look at that, what I've noted is that a judge's failure to apply the Ugranaft approach to this issue is not in itself a misdirection, but may, you say, lead the judge into error.
Yes, because what I say is that the Ugranaft approach sets out with such clarity as to what considerations need to be taken into account, that particularly if one focuses in the wrong way, then the judge can be led to a path that doesn't create a just and proportionate result, and that the penalty becomes disproportionate in relation to what the actual offence is. So Francis and Al-Assad at tab 8, it's a decision of Mr. Justice Henderson, as he then was. And it's a case about the obtaining here of freezing orders, a worldwide freezing order. It's a freezing order in relation to the proceeds of sale of the house known as Wittenhurst in Highgate. The judge had to deal with a number of issues in relation to costs and procedural deficiencies, and he deals with those at 75 to 78, and it all relates to a hearing before Mr. Justice Morgan, matters that were not drawn to his attention. The first issue was full and frank disclosure. As I say, the judge deals with these matters at 75 and 75 to 78, and in particular there was the issue of the relationship between the liquidator and the litigation funder. We then see at 83, perhaps actually if my lords and my lady can just read 81, because that is also one of the first issues that the court had concern about. And then at 83, turning over the page, there's a section then on the duty of full and frank disclosure, and at 83, particularly the fact that there was a failure to explain to the court that information had been obtained unlawfully. So in this case, the application had been made improperly without notice, there were procedural flaws, and the duty of full and frank disclosure had been breached in two ways. The court marked its disapproval and dealt with matters, firstly in terms of costs, by making an award for indemnity costs. And then when deciding whether to grant a new injunction, granted one on a more limited basis, and that's dealt with principally at 102 through to 106. the court did here was examine how serious and culpable was the non-disclosure, the public policy in relation to what a suitable penalty should be, the need for a suitable deterrent, and then balancing that with the interests of justice. And in so doing, the court decided to keep the injunction in place.
So just to make sure I've understood what happened, there was an application made to Mr. Justice Morgan
Yes.
on the 20th of July, which we see from paragraph 12. Mr. Justice Morgan,
That was without notice.
that's without notice, as my lord says. Mr. Justice Morgan grants an injunction without notice on that day,
That's right.
and Mr. Justice Henderson is then asked to discharge it. It looks as though he does, because then there is a separate
Yes.
application on the 7th of September, to which he refers at 92, for a more limited injunction. So it's not a question of reimposing the original order, it's a question of making a fresh order inter partes now, and it's that which he is considering from 92 onwards.
And I mentioned that just a moment ago, my lord. That
Yeah.
this
That's
is
in relation to different property.
It's a more limited injunction. And the point and my submission is that in that case, again, it's the wide-ranging armoury that the court has that is referred to in Tugashev by Mrs. Justice Carr, and also even though he doesn't go through the checklist in quite the same way that Mr. Justice Christopher Clark does, it's the same principles that he's looked at the balance between culpability, the need to protect the administration of justice, and then the wider interests of the parties and looking forward, and has decided that a more limited injunction is suitable.
Right.
But these are different properties, these properties in Spain. At 92.
Yes, it's the three Spanish properties, yes.
Yes.
As I say, I'm not trying to draw anything on the particular facts, my lady. The point is that in this case only concerns one property, and the protection and the prevention of the sale and registration of one particular property. It's again, of course, a slightly different factual situation to the one that we see in Francis.
Right, so instead of an order restraining Mr. Al-Assad from removing assets from England and Wales, there is now an order restraining him from dealing with 3 properties overseas.
Yes.
It's a completely different animal.
Well, no, my lord. It is in the sense that the assets are different to the one that was the subject of the original injunction. And I'm not suggesting that I have to move on from the idea that the injunction shouldn't have been discharged in the first place. It was discharged, and I accept that. It's entirely the focus of these submissions is all about reimposition and what the right sanction should
Yes.
have been in terms of preserving that asset until trial, and then at the same time the court marking its disapproval for my client's behaviour.
Right.
So is Mr. Justice Henderson's judgment anything other than an application of the relevant principles to rather different facts?
Well, of course, my lord, all of these are to
But does it set out any new law or different law?
what I say there is that he's not to the extent that there is a setting out of the principle in the way of the previous cases that I've referred to, but what I suggest is that he's carried out a very clear balancing exercise in terms of the principles that needed to be considered that I say did not occur in this case.
So it's an example of the application of the right principles to different facts.
Yes. So I'm going to try and tie together some of the strands that have been set out in those authorities. And I entirely accept that the court will use these principles sparingly. There is a penal aspect to the matter in terms of what is a suitable punishment. In terms of the court examining culpability, in assessing matters in a context and examining how culpable a party is, that in my submission will only take the court so far. The court then needs to examine an element of harm. What do I mean by harm? Particularly the harm to the other parties who were the subject of the injunction, whether there really has been an improper advantage that's been gained, and secondly, harm in terms of a wider concept of harm to the administration of justice, particularly as a policy of deterrent. There is then a next stage, which is what is the effect on the applicant if the injunction is discharged and not reimposed. Where will that leave the applicant? Is that in the interests of justice? And then looking back, once the judge has gone through those exercises or those criteria and considerations, there is then the overall justice test, which is and that's really looking back and looking forward. And it's the proportionality between the offence and the punishment. Because of course, if every case of material non-disclosure leads to that sanction of discharge, then it becomes a very blunt instrument. And in my submission, a range of options, as I've already explained, a range of options would be open to a judge and were open to the judge in this particular case. There is, of course, the embarrassment and the disapproval that is set out in a public judgment. There is the use of costs orders, particularly indemnity costs, a more time-limited or more limited in scope order, and then conditions attached to any order through, for example, any fortification of the order or payment into court.
In terms of deterrence and the preservation of the proper administration of justice, there must be, I would have thought, a very high value placed on the production to the court on a without notice application of a document found to have been, quote, a complete fabrication, unquote. A finding which you cannot challenge.
No, I can't challenge that, and I don't seek to. But what I come back, my lord, to the principles that an innocent breach may well lead to discharge without reimposition.
Yeah.
And multiple serious breaches may well lead to no discharge or discharge with reimposition or a more limited order. And in my submission, that really, when one balances, culpability is not culpability may well be the starting point, but it certainly isn't the end point. And this is where I say, with the greatest respect to the judge, she erred because she became overly focused on the culpability, on the points that I'm stuck with, that what she's already said about my client, and there is nothing I can do about that. But I do say that that there was an imbalance here when it came to looking at the next tests
Right.
that we go on to. Right. My Lord,
So that's the end of your section 1.
that's the end of my section 1.
Right.
So section 2 is the application to the present case. Now, in my submission, I have to accept what the judge says about the matters, and I'm not going to try to go behind them. But I do submit, and Mrs. Justice Bacon, without going behind any of the facts, she does find that junior counsel who appeared before Mr. Justice Mann, and it's in the note of that hearing, refers to there being a second award. Mr. Silver, in his first witness statement, made reference to that. And in my submission was that there was no attempt there to obtain an unfair advantage. It's still a matter which Mrs. Justice Bacon noted her disapproval, but those matters were actually, in terms of culpability, I note that those matters were still raised.
Yeah.
Even in Mrs. Justice Bacon's judgment at 40,
At?
subparagraph 3.
Sorry, which paragraph?
40.
40.
Roman 3.
Yeah.
Again, she makes reference to Diane Schwartz's evidence that there was an oral award. She refers to his witness statement. And again, I don't seek to go behind this because she's made those findings. But what I do seek to suggest is that when one balances these issues, just dealing with, and just very briefly dealing with culpability, it's the other factors that I need to spend far more time on, that the court's particular finding and issue was with Simon Silver's first witness statement and the fact that it exhibited what was in effect a purported translation of the second award. And that's where my client particularly fell into error. The judge, while finding
But
that...
it's a bit more than that, isn't it? Because you didn't explain you got the £500,000 back.
Well, I'm going to come to that, my lord, as well. Absolutely. And again, I don't seek to suggest that these weren't important points that should have been referred to Mr. Justice Mann, because I do. And in fact, I mean, just turning to that point, my lord, firstly, before Mr. Justice Mann, the appellant had provided evidence, which we see at page 99 of the supplemental bundle, of his assets, significant assets that were so a schedule was provided, and we see total assets at £77.5 million and liabilities at £49 million. Does my lord have that?
Yes, I'm just seeing what it is. This is what? This is a seems to be an application to a bank, is that right? Or something?
Yes. So this was the Mr. Halpert's financial details that he provided to Mr. Justice Mann,
Oh, I see.
because he gave an undertaking, cross undertaking.
Yeah.
So what I suggest and submit is that the judge, both Mr. Justice Mann and Mr. Justice Bacon, had that. Now, I don't seek to downplay at all the fact that the appellant should have informed Mr. Justice Mann about the £500,000 having returned. What I do note is that Mr. Silver, in his second witness statement, at page 231 for your record, at paragraph 6.3.6, made it clear that the sum of £500,000 remained available. And during the hearing on instructions, it was made absolutely clear by me that the appellant was prepared to pay the sum of £500,000 into court as a condition of the continuation or the reimposition of a new injunction. And what I say to that is that that matter did not find its way into the judgment when dealing with the question of the deposit or the question of regrant.
So this is a point the judge failed to take into account.
Yes. There is no mention of it at all. And what I say is that even though, and again, even though my client was in the wrong for not explaining those matters and has had the appropriate criticism from Mrs. Justice Bacon, it would have been a matter that she should have taken into account, because if there was an unfair advantage being obtained in the sense that that money had been returned to my client by the Beth did, then this was a way of fortifying any order and ensuring that my client was essentially, as I say, good for its money in two ways. One, because of the balance sheet that Mr. Halpert provided, and secondly, through actually providing the £500,000 into this court.
Just to explain for a moment, how do Mr. Halpert's assets come into this? He wasn't offering a cross undertaking, was he, personally? He was?
He did, yes, and there was a personal cross undertaking in the order.
Right, thank you.
Yes. The third issue was whether a sale had actually arguably occurred. And again, I have to accept the findings of that. But whilst I can't challenge those findings in Janus-like looking back, I can now do focus my submissions on the failure, which in my submission were clear, of the judge not looking forward.
Can we just pause at that point?
Yes, Michael.
I'm looking at paragraph 70 of the judgment, which the judge refers to some evidence.
70.
70,
Yes.
page 62, which I infer she accepts, at least for the purposes of the hearing before her. And she says the sale to UHL completed on the 4th of November 2020. And I know you quarrel with that word completed.
Yes.
The TR1 was signed on the same date, that is to say before Mr. Justice Mann made his order, and the signed TR1 was filed with the Land Registry on the 10th of December 2020. And that, I think, was the date on which Mr. Justice Mann actually made his order.
It was.
And if we go back to the terms of the order, which the judge sets out at paragraph 20,
And the hearing before Mr. Justice Mann started at 4:30 on the 10th of December.
yes,
So it may very well be that the filing had taken place before
yeah,
that time and before whatever time he made his order.
Maybe my client wasn't told about that.
right.
about
So,
that.
so if we look at what the respondents must not do,
Yes.
in the event that any sale, disposition, encumbrance or other dealing of the property has taken place which could be registered, and that must include a signed TR1,
Yes.
take any steps to register. Now, in order to take steps to register, what you have to do is lodge it with the registry, and that's been done. That was done on the 10th of December, according to the judge, paragraph 70. So when she says, well, what's the point of reimposing this injunction, she's right, isn't she? You didn't ask, as I understand it, for an order that UHL withdraw their application or tell the Land Registry not to register it.
Well,
You were asking for this injunction, as I understand it, to be reimposed.
my lord, that's not quite the case, because
Right.
in further submissions and in all submissions, it was made clear that there were other ways of dealing with
Well,
the
what
matter
were you
rather than
on,
just
what order were you
reimposing.
asking the judge to make?
That, well, firstly, there's still this issue as to whether completion has taken place or not, so that if completion, assuming it had taken place, then an order to prevent registration of the title
Against whom?
Against
Against
UHL.
whom? The Land Registrar?
Well, it may have to be the Land Registry.
Well, did you ask for an order against the Land Registrar? Did you join the Land Registrar?
Well, my lord, no, but it would have been there could have been an order that would have prevented the UHL from taking any further steps.
Well, what further steps did it need to take? Having lodged the TR1 for registration on the 10th of December, I mean, what were you going to ask for?
Well,
An order that shouldn't answer any requisitions raised by the Land Registry. I mean,
it could have withdrawn the application.
well, did you ask for an order that it should do so?
My lord, no.
No.
But
So what order were you asking the judge to make?
we were asking the judge principally to maintain the order of Mr. Justice Mann.
Right.
But if because at that point in time, and I still maintain even today, the underlying facts of the case remain somewhat unclear as to what has actually occurred, that what would be needed was an order that would preserve and prevent UHL from selling the property onto a third party.
Right. Do you challenge the judge's apparent finding that a signed TR1 was filed with the Land Registry for registration on the 10th of December 2020, whether or not completion, as you understand it, took place? The document was filed for registration.
Well, we've certainly seen the TR1 on the 20th of January in Mr. Volkov's statement. That was the first time that it was provided. I can't recall whether there was a document showing that it had actually been sent to the Land Registry itself, but certainly that is what was said was done, and so that was the position that the UHL was saying to the court before Mrs. Justice Bacon. I accept that.
Right.
And so the allowing for the uncertainty that you explain as to the facts, you wanted not only the continuation of Mr. Justice Mann's order, but you would have wanted also an injunction against UHL against dealing with the property in any way, if it was in their power to do so.
That's right. That's really it was
And
about
is
the
that-
preservation of the asset.
And is that
until
something
trial.
that you did in fact apply for before Mrs. Justice Bacon
Well,
in any formal sense?
the focus of the hearing before Mrs. Justice Bacon was really on the materiality of the documents that weren't provided to Mr. Justice Mann, and whether there was material non-disclosure. And then once the the focus was far more on that, and then in terms of what to do, in terms of if she was going to keep an injunction in place. And so there were two aspects to the submissions. Firstly, that there was no force in what the respondents were saying, and secondly, that if there was, that the injunction this was a situation where either the injunction should still remain in place, or if it was discharged, there should be a new injunction, whether a more limited one or on the same form, should still be imposed.
Can we go back to paragraph 70?
Yeah.
What the judge says is, on the face of the evidence, the sale enjoined by the injunction has taken place, and the continuation or re-grant of the injunction against Cityvalue will therefore be of no practical effect. If, as seems to be the case, she accepted the TR1 had already been lodged with the Land Registry, that would appear to be correct. There is no suggestion in the following paragraph that I can see that you were applying for some different form of order. You were saying, oh, no, there hasn't been completion. So this order, Mr. Justice Mann's order, may have practical effect. But if you were applying for a different form of order, such as the one my lord suggested, there's no trace of it in the judgment. There's no application notice asking for a different form of order.
And I accept that, my lord, because the principle, the way the hearing developed, and the principle behind the hearing were those two aspects that I just referred to. And I was making the submission, which I still maintain, that there isn't evidence of monies having been transferred and necessarily of completion having taken place. And that's why she makes the reference to my submission on that issue in paragraph 71.
And she goes on, of course, to consider your client's possible claim against UHL, in relation to which she focuses not on she focuses on the part of the original order that prohibits it from acquiring any interest in the property. But she then focuses on the question of what cause of action you have, if any, that establishes a proprietary interest in the property if it's got into UHL's hands.
Yes. Well, I'm going to develop
That's a separate point.
Yeah. So, as I
it
said,
doesn't look as if she can be criticised for not having thought about the grant of a modified injunction against UHL to prevent it from taking any further steps to register its title, if any, or to reverse any steps that had been taken, because it doesn't look as if that was submitted to her.
well, that wasn't the focus of the hearing,
No.
because of the way the facts were developing, my lord. So obviously, if the issue of completion was still very much a central submission on my part.
Yeah.
In my submission, going back just to end this section on culpability and looking back and then turning to the looking forward, even looking at the findings of Mrs. Justice Bacon, in my submission it is not a helpful exercise to count up the number of breaches and simply suggest, well, there are 4, or in my learned friend Mr. Levy's submission there should be more, and using that as a starting point. It is not a helpful exercise, as we've seen in the authorities. I do submit that the findings are not as serious, albeit it's a slightly invidious and difficult position to try to compare facts in cases. But I do submit that it's not as serious as what happened in Yugreneft and Tugashev, and that the errors that were found by the judge in this case are very much focused upon the way the application was prepared, particularly by my client's former solicitor. The focus needs to be on the section of the judgment beginning at paragraph 66, where she does turn to the exercise of discretion, and the starting point was the discharge of the injunction. I accept that she goes on and looks at injustice, but what she did not do is look and split those matters in the way that Mr. Justice Christopher Clark did in Yugreneft. So what is the importance and the significance of the outcome? In my submission, the appellant would still have been able to have obtained injunctive relief. The £500,000, as I've dealt with, my lord, could have been paid into court, and Mr. Halpert had significant assets way above the sum that was in dispute. And I do say that the appellant maintains its position today that no evidence has been provided, save for the TR1 and then more recently a contract that says that completion took place and the allegation is made that purchase monies have been paid. Now I contrast this type of injunction with a freezing injunction at the other end of the scale. And this type of proprietary injunction in my submission is different. And in terms of what the effect of non-disclosure and then of discharge would be, it would be all the more serious in this case because my client, who has a specifically enforceable contract to purchase the property, is left with a third party alleging that it has acquired the property and is free to sell it.
Just going, I'm sorry to go backwards.
Sorry.
Could you just show me where Mr. Halpert either gives or offers to give the cross undertaking? I don't think it's in Mr. Justice Mann's order, is it?
Yes.
As I can
The
see.
order.
The order we've got at tab 18, I think.
Yeah.
Mr. Halpert is not a party to the action. The undertakings are in Schedule 2.
Page 1 except for paragraph 1. This undertaking has also been given personally
Oh, I
by
see.
Alexander
Yes,
Halpert.
thank you very much. Yeah. Thank you very much. I missed that.
Yep.
So the next stage is to look at the merits of the appellant's claim. There's the claim against the first respondent in relation to specifically in relation to enforcing the arbitration award. Then there is the second claim against the second respondent. Now I do suggest, I am going to make some submissions about this question of completion. I know I've already spent some time on it, but I just want to flesh this out. The second respondent provided the TR1 on the 20th of January. It showed a significant disparity between the agreed price in the option of 2.175 million, which is at page 66 in the supplemental, where there was a call option fee of £30,000 and a deposit of £670,000. At page 47 in that bundle, we see a contract for the second respondent to sell the property on for £12 million. See that at page 47 in the supplemental. should have drawn.
47.
I mentioned that.
Starting at 44.
Yeah, well, I started at 66. Actually, was the option.
56.
66. So 66 we see the option, 47 beginning at 44, there's a contract.
So this is an onward sale by
Onward
UHL
sale.
to Beckton Development.
Yeah.
Yes?
Then at page 183 we have the TR1. And that's the document that was received on the 20th of January. There's a price of £1.1 million. Now what I say is that the original skeleton submissions prepared for the hearing before Mrs. Justice Bacon at 67 Roman 1 and 2 raised this issue of completion. It was raised in the draft particulars, which we see at the back of the core bundle. I can take my lords and my lady to that. Tab 23.
I'm sorry, where have you gone?
I've gone to tab 23 in the core
Thank you.
bundle.
Thank you.
So this is,
These are the draft particulars that have been slightly amended at tab 24.
these were put forward when?
This was before the court, before Mrs. Justice Bacon at the last hearing. This is the document that was before her. And the paragraph 59 and 60 dealt with the question of completion and in the prayer.
And
Now,
remind
it's
me,
not-
you have, is it right that your clients have issued proceedings against United Homes?
Yes. And
And
they've
not yet
actually been served, I believe, they were issued in February and they were served on Monday.
And have they been served with a final version of particulars of claim?
With the version at tab 24, my lord. And again, I'll explain the difference when I come to the question of the proprietary injunction.
Can I just understand the point that's being made here? If I agree to pay £2 million for a property, and in fact I only hand over £1 million, I can understand that the seller is entitled to refuse to execute the TR1 in my favour. Because I haven't done what I said I was going to do.
Yes.
But suppose the seller does execute the TR1 in my favour. Normally he would have a lien, would he not, on the property for the balance of the purchase price, vendor's lien. And I would be entitled to register the TR1 subject to the vendor's lien, would I not?
Well, my lord, in most circumstances, that would be right. What we don't have here, notwithstanding requests, is any explanation as to why there's been this sudden drop in price of effectively a 50%.
Well, that may be so, but the point is that the TR1 has been lodged at the Land Registry for registration. If there is money outstanding on the purchase price, that would not prevent the registration of the TR1 transferring the title from Cityvalue to UHL, would it? That's why I don't at the moment see what the relevance of completion is. As between Cityvalue and UHL, I understand entirely.
Yes.
That it means that Cityvalue could say, well, we're not signing the TR1, you can't have it.
Yes. I understand the point, my lord. I mean, the principal submission that I made before Mrs. Justice Bacon and that I make today relates to the wider claim rather than the question of completion. It's the proprietary claim against the on the constructive trust.
Right, but that doesn't depend on whether or not the property, the sale has been completed in the sense which you use it. So I simply don't understand why we're spending any time on it at all. I mean, if as you say, there is an adequately pleaded claim for knowing receipt,
yes,
then you may well have a proprietary claim. If, on the other hand, your claim is based on dishonest assistance, then you have a personal claim, but not a proprietary one.
yes.
And that's true whether or not the sale has been, quote, completed, unquote.
I follow that, my lord, and that is why, as I say, the completion issue takes up 1.5 paragraphs or so of that pleading. And I note what my lord says, and I'm not going to labour points that perhaps take the court along a path that it doesn't need to necessarily go down.
Right.
But what I do say, just in terms of dealing with that point, is the way that, before I do move on, is that in paragraph 71, I submit that Mrs. Justice Bacon was too quick to dismiss the issue because she used language that it was pure speculation, that she should have viewed it within the context of the case against the first and second respondents, rather than as a standalone matter, and failed to contextualize the allegation, and similarly the allegation in relation to the proprietary claim. Moving on to the proprietary claim, she alleged and said that the proprietary claim was unclear, and in my submission that was not the case then, and it is not the case now. The learned judge appeared to have been heavily influenced by the submission from the second respondent that it had in some way been ambushed by my client in receiving draft particulars at about 11 o'clock in the morning for a hearing that was going to start at 2 o'clock. Now, in my submission, again, that all is tied up with the looking back and the culpability and behaviour of my client, rather than actually looking forward at the claim itself. The matters, in fact, had all been addressed in the skeleton, albeit only provided a couple of days before the hearing itself. But in my skeleton submissions, I set out what the basis of the claim was going to be. And my lord, I can take you to that if you actually need to see the actual page reference of where I set out the basis of the claim. It was made clear in Mr. Silver's second witness statement that the particulars were being drafted, so that cannot have come as a surprise. And the matters were dealt with comprehensively in my skeleton and orally. And therefore, I submit that if the appellant had wanted this to be a true ambush, it was a very odd and strange way of going about it, because one wouldn't ambush in that way. What I do submit is that this was a perfectly valid proprietary claim. It was made clear that this was a claim for knowing receipt, and save for some very minor changes to paragraph 65 and to the prayer, that the pleading remains exactly the same. Now, in the light of what my learned friend said, and the, if I can put it this way, the complaints made about the pleading, there was a minor amendment, and we see this at 24. And there is a difference between paragraph 65. I should say one didn't need permission because these were never served, they were in draft. So paragraph 65. Unfortunately, for some reason, it's not been underlined, but
Yeah.
there's a very small difference between paragraph 65 in the original and the new 65.
Yes, and or its knowledge of the facts set out in 63.
Yes.
And I suppose the heading above 61 ought to be changed as well.
Yes.
The original pleading is specifically dishonest assistance and not anything else. Well, I mean, apart from conspiracy and procuring a breach of contract.
Well, my lord, with respect, I do say that the facts that were pleaded really amounted to a knowing receipt. It was made quite clear that the...
Yeah, you say in 61, the original,
Yeah.
Once the claimant exchanged contracts, it
Yes.
had the benefit of the property under constructive trust. So
Yes.
you're saying it was the exchange of contracts that
Yes.
created that trust. You're saying in 63 that UHL knew that there'd been an exchange of contracts.
That's right.
And nevertheless, you say in 64 it continued with the purchase.
Yes, and then I say at 65 that it now holds it as a constructive trustee
Yeah.
on behalf of the claimant. So
Yeah, I can see how you can
yeah,
get
yes.
a knowing receipt claim
Yes.
out of those facts.
And then I also
Not saying you did, but you could.
yes, and then my lord, what I also say, if one turns to the prayer, that again at number 2, a declaration that the property is held on trust for my
Yeah.
client. And again, just to make matters absolutely crystal clear, I have amended paragraph 2 on page 217.
And if you don't get an injunction, you can still pursue this claim, can't you? Because you can trace the property.
Well, the difficulty there, of course, my lord will be well aware that it just adds layers of complexity to the claim when, again, if we go standing back...
Why?
And
what complexity? You've still got to prove the same facts.
well, my lord, this is the company, UHL. One has no idea what assets it will have in the future, and how matters will pan out if the property is allowed to be sold to another party, to a fourth party, and then again, as I say, just simply my submission, rather than preserving the asset, which makes a far neater claim for the court to deal with, rather than adding a tracing element into the proceedings.
Yeah.
But where this really goes to, my lord, is the principle of whether the looking forward and the balance between the looking forward and the looking back. Because what was clear from the judgment was that Mrs. Justice Bacon didn't really accept that this was a potential proprietary claim. And notwithstanding, and I'm going to explain some of the information in terms of law that was before the court. So in my submission, there is an error in legal analysis. And this is important because this does go to those factors, whether it's the Mrs. Justice Carr's factors, the interests of justice, or whether it goes to Mr. Justice Christopher Clark's factors. As I say, I don't seek to try to particularly differentiate between them, but those factors in terms of looking at the claim, looking at the merits and standing back, and then looking at proportionality of the punishment, this goes to the very heart of that. I explained the claim in the original skeleton submissions at page 106. 106. I think that's in the supplemental. I haven't actually written that in my note. So forgive me if I... It's in the core bundle.
Yes.
I'm sorry, 106 in the call.
Yeah, core bundle 106.
And I set out there a whole section from paragraph 66, well, that's the completion issue, through dealing with the law on the proprietary claim, and all the way through to page 109.
Sorry, where's the proprietary claim? It's Roman 3, is it?
Yes, that's where that's where it starts.
So it's Roman 3, you say, trust created or
Yes.
beneficial interest passes on exchange
Yes.
of contracts.
And then I deal
5,
with the
you
facts.
say that the second respondent provided dishonest assistance in that it knew of your client's interest. Then you refer to Snell's explanation of dishonest assistance. So far, we've got nothing to do with the proprietary claim. And then when do you say, well,
Well, I
there's
say
knowing receipt?
that is then was explained orally, and then in further submissions at 153.
153.
53.
Yeah.
So the judge, after a day and a half hearing, asked for further submissions on a number of different issues. And these were provided on the
So
23rd.
154 Roman 4, you now refer to knowing receipt.
Yeah.
Yeah. Yeah. Right?
I also went on to explain in paragraph 4 and 5 of that document that the return date on an interim injunction was not the forum for a detailed analysis of the merits of the claim. And what I say to that is that the learned judge veered too far into the territory of the trial judge.
Well, wait a minute. You may be right to say that you shouldn't analyse the merits of the claim, but you've got to be satisfied the claim is made.
Absolutely, my lord, but
Yeah.
what I do submit is that that claim was there and that she still went too far, because this was an example where, in my respectful submission, she started analysing matters at an interim stage where it was going too far at that early stage to try to decide whether there really was a claim for knowing receipt, and dismissing that too easily. And I refer to, in the authorities bundle at tab 12.
So, wait a minute, just before we go to more authority, let's just see what the judge says about that.
Paragraphs
At
76 and 77.
Yeah, 74 she deals with the history of the pleadings. 75 she agrees that that's, with Mr. Levy, that's not good enough. Then she doesn't say, then she says that it wasn't in your skeleton argument. And then she says the outline of points relevant in the skeleton argument served, fell short of what was required. So that's all the original skeleton. And then at 77, she refers to the knowing receipt claim, but she says that's not been pleaded and there's no draft amendment.
Well, firstly, as my lord said, that in my respectful submission, the original pleading was sufficient for a knowing receipt claim. It did not need, the facts were there. Where she falls into error, in 76, my lord, she follows a submission made by my learned friend that to rely on the case of Williams and Central Bank of Nigeria and the principle that this was the type of constructive trust that wouldn't create a proprietary interest. And in my submission, she fell into error there, because when the contracts were exchanged in 2015, and at the very latest when the Beckton made its award on the 1st of October, there was a constructive trust in favour of my client.
Yeah.
And so that pre-existed the sale. Now, whether I'm going to be right, whether my client's going to be right or wrong ultimately... sorry.
Just a minute. I just need that unpacked a bit more. There was a constructive trust on exchange of contracts as between your client and Cityvalue.
Yes.
But if there is dishonest assistance in a breach of trust, there is always a pre-existing trust relationship between the trustee and the beneficiary. The question then is, if somebody dishonestly participates or assists in a breach of that pre-existing fiduciary relationship, does the dishonest assistant himself hold the property on constructive trust?
Yes.
So it's not enough for you to establish that there was a pre-existing fiduciary relationship between Valbonne and Cityvalue, because even if there had, because if there wasn't, then there's no question of dishonest assistance in a breach of trust. The point doesn't arise. But if there was, then the mere fact that there has been dishonest assistance in breaching that fiduciary relationship does not of itself create a proprietary remedy against the dishonest assistance. That's what Williams says, and the judge in 76 is right to say that, isn't she?
Well, my lord, let me develop the legal analysis which I've set out, and will take you to some passages in Lewin and Emmett that I say that this falls into a different category, and that the party who actively, knowingly purchases the property which is being held on trust, that they knowingly receive that as
Well, that's knowing receipt.
It's knowing receipt.
Well, it's a different claim.
But what I submitted...
And it's a claim which, I mean, as my lord says, you might be able to spell out from your original pleading, but it's a highly misleading way of putting it forward in that original pleading, as compared with how you put it in the second version.
Well, two things I say to that, my lord, was one, it was explained orally, and secondly, in the further submissions, the matter was clarified.
Yeah.
So and yet, instead of the analysis being adopted by the judge, instead, what she says is that I haven't dealt with the matter, which actually is simply...
No, she says you haven't pleaded it, and you haven't put forward a draft amendment.
Well,
she doesn't say anything further than that in 77.
Well, no. What in 77? What I mean by that, my lord, is she says Mr. Blakey didn't take issue with any of those submissions because I wasn't going to take issue with them, because I am effectively I'm taking issue with what Mr. Levy was saying by putting forward a very different case in terms of explaining why this was a claim for knowing receipt.
Yes. Which she recognises in the first part of 77.
And well, it wasn't, I mean, just in terms of dealing with that point, there were a number of issues, my lord. It wasn't in order to satisfy a point that just simply that my client wanted to make or I wanted to make. There was a number of issues that were still live and needed to be dealt with in writing.
Yes.
My submission, my lord, is that before this judgment was written, my lady, Mrs. Justice Bacon, had the very clear submissions as to what this claim not only was about factually, which hadn't changed at all, and secondly, what it was in terms of law, both in terms of clarifying amendments, explaining that through the written submissions, with references to particular texts. And she had that information. And so this is where I say the balance is skewed, because she's been too quick in my respectful submission to let culpability outweigh the wider interests of justice.
So what you say, let me just see if I've understood this. You say, well, 77 does contain an error because before the judge gave her judgment, you had explained the factual basis of the claim.
Yes.
In your post-hearing submissions, you had put forward an alternative legal basis for the claim.
Yes.
The judge rejected it because it hadn't been formally pleaded in particulars of claim, rather than rejecting it as being an untenable claim.
Yes.
And that was, you say, an over-concentration on formalism, which led her to fail to take into account the underlying strength of that proprietary claim.
That is precisely it.
Yeah,
my lord.
right, understand
Yes. Yeah. And so what I say, and again, I was just about to turn to an authority at tab 12.
What's it going to say? What's the proposition which you want to cite it?
It's in relation to how far a judge at the interim stage should look at the facts of a claim. I mean, it may be that the court considers that to be a rather trite.
Well, we're in American Sinamid territory, aren't we?
Yeah.
Do we need to know any more than that?
Probably not, my lord. So, as I say, in my submission, it's not the forum for resolving finer points of law or fact.
No, I mean, your point really is the judge was wrong to rely on the lack of a pleading.
Yeah.
She didn't and couldn't have rejected the claim as being legally untenable.
Yes.
Nor could she have rejected the facts as being unarguable. And the reason that she's given in paragraph 77 is not a good one, because you didn't have to plead it at that stage.
And what I say to that, my lord, is that we're not talking about a pleading that required significant amendment.
Yeah.
We're talking about really a few words in one paragraph and in the prayer.
Well, you're talking about a different legal analysis of the same facts.
Yes. That's precisely the point. Just to deal with that very briefly, so that the court has all of this. At tab 18, I've referred to Emmett and Farrand and Lewin at 17, so that.
Do we need any of this?
Well, my lord has. I think my lord understands the legal analysis, and
yes.
So probably not. But just again, rather than look at the points, I will then just explain very quickly that in my submission, the fiduciary relationship existed before any sale to UHL, which took it into a completely different category to that in Williams, which isn't really a trust situation arising, because it doesn't arise before the breach. And I do submit that the factual narrative here was perfectly clear, and yet the learned judge failed to deal with the issue going forward and decided the matters essentially wrongly as a pleading point, as my lord says.
Yeah.
If the pleading wasn't as elegant as it should have been, then I stand here and that is one of those things that happen. But my client shouldn't have been penalised for that. And as I say, it was dismissed far too quickly and easily. And it's a very clear example of looking backwards and not enough going forwards.
I suppose you might be able to say she may have been influenced in that also by the adverse view that she had taken, as explained at paragraph 75, of the delay in proceeding against UHL at all.
Well, I think that's absolutely right, my lord, because the colour and the tone of the judgment, as I say, continues in terms of the extreme displeasure with my client in terms of its culpable behaviour, and the late production of draft particulars is seen very much through that same prism. Whereas in my submission, it was important to detach the two because they have really nothing to do with one another. The point in terms of having to look at the facts and a draft pleading, those had to be looked at entirely separately.
Well, I see the point, but I must confess that I have the feeling that if I had been sitting at first instance and had faced the history that she relates in paragraphs 74 and 75, it might have affected my view of the basis of claim as eventually put forward if I found that the draft particulars of claim as eventually formulated didn't actually show the real claim that it turned out during the hearing that you were wishing to put forward.
Well, as I say, I mean, that may be understandable, but in my submission, again, respectful submission to the judge in this situation, the necessary, after one has looked at culpability, it's necessary to pause and go on to whether it's quite as formulaic as the Ugrineft or the Tugashev tests, but to step back, look at the penal nature, look at going forward about the claim, and then step back even right at the end and look at the matter as overall justice in terms of, perhaps one might call it sort of totality in the criminal sphere, but proportionality here, and look at really, is this the appropriate penalty for what has actually occurred?
Yes.
My Lord, I was going to turn finally to an actual analysis of the allegations and the facts against the second respondent, so that my lords and my lady understand what is actually being alleged and why.
Well, isn't it quite clear what's now being alleged? You say that your client had a contract with Cityvalue that created a constructive trust on well-known land law principles. UHL knew all about it, not least because of the unilateral notice. Nevertheless, they went ahead with their purchase, and therefore they knowingly received trust property.
And that's right. And I also say again, just to add into that, I am going to draw, with permission, just to a couple of documents. There's one at 172 in the supplemental bundle. That's the letter from my client's former solicitor.
172?
Yes, my lord. It's a letter from Bude Nathan Iwania Solicitors, dated the 11th of April 2019, and that's sent to UHL's former solicitors with a statement of objection at 173, explaining why it has a UN1 in its favour. Secondly, I draw my lord's and my lady's attention to the fact that the allegation that's made by one of the three Dayanim, Diane Schwartz, in his witness statement, is that threats of violence were being made and interference in the arbitration process, and that those threats came from the second respondent. That did not feature at all in the judgment of Mrs. Justice Bacon, again, in my submission, because she viewed matters through the prism of the past rather than looking to the future. And we see Diane Schwartz's witness statement at 286. It's at tab 9.
Of the supplemental bundle?
Yes.
Well, for some reason, supplemental bundle tab 9 is completely blank.
I have it.
You have it, my lady.
Would do first witness statement of
Ah.
Diane Schwartz.
Yes. Do you have it, my lord, at
Tab 8.
286?
I've got it tab 8.
Oh.
Is that the same one? First statement,
Yes,
30
there is only one statement.
Right, 31st of December 2020.
That's right.
Yes?
I think it's probably behind the wrong divider.
Yeah.
And I would ask you to read section 5 on page 3 of the statement, 288. Please.
Yes. Paragraph 5.4.2.
Yes, thank you very much. I'm not suggesting that Mrs. Justice Bacon should have been making findings at that stage, or necessarily that what she should have done was have in mind and in carrying out her legal and factual analysis, the serious allegations that were being made. None of that, none of the factors such as the threats or knowledge came into her judgment. So there needed to be a link from the merits to injustice and looking forward. And again, stepping back and looking at overall justice, in my submission, this was a case where, even if the court considered the matters to be serious, and again, I don't seek to go behind that.
I'm sorry to interrupt you again, Mr. Baker. I'm just looking at your grounds of appeal to see whether this is where this is raised, and as far as I can see, it isn't. Threats of violence doesn't seem to feature in the grounds of appeal. I think if they had done, either in the grounds of appeal or the skeleton argument, I might have read Diane Schwartz's witness statement, but I haven't before today. Perhaps you'd show me where you rely on this.
What I say there, my lord, is that all of this comes within the claim of this section of the claim against the second respondent. So it's grounds 20 to
Ground 20.
Grounds 20 to 26.
Serious allegations of dishonesty.
Yeah.
Where are the serious allegations of violence?
Is it at the last but one line on 21, interfered in the Beckton process? A party who's alleged to have been dishonest interfered in the Beckton process
Used threats.
and is said to have used threats.
Yeah. Right. Yeah. Right. It's there.
Yes. So, yes. Thank you very much, my lord.
Yes.
So in my submission, when stepping back from these matters, these matters were serious issues before the judge, and there was and because of the overfocus on what had actually happened in terms of the material non-disclosure, the judge went on to ignore the offer of the £500,000 to be paid into court, which would have remedied one aspect. Secondly, effectively ignored the knowing receipt claim, or at least didn't give it due weight, both in terms of the facts and the law. And then thirdly, didn't carry out the exercise that I say was needed. And so when it comes to the image of Janice looking in both directions, there really has been here such an overwhelming focus on looking back that it has clouded the vision of looking forward, and that hasn't taken place. To quite the extent that it should have done. Now, in my submission, there were other ways, as I've already submitted. I'm not going to labour the point for the court to deal with its disapproval. My client has already, in order to get to this stage, had to been severely punished in very high levels of indemnity costs, and and also had to deal with the public nature of a serious judgment about its behaviour and of its former solicitor. So those, I'm not going to touch on the respondent's notice at this point, and I note that it's now 12:30. My lord, my lady, do you have any further questions for me at this stage?
No, thank you very much, Mr.
Thank you.
Blake. We will rise for a few minutes just to see where we go from here.
Rise. Just letting you all know, the live streaming is still running. It won't be turned. Council, are we ready? Yes, thank you. Court rise.
Well, Mr. Blaker, you have very tenaciously said everything that can be said on your client's behalf. but we don't need to trouble Mr. Levy. So we will dismiss the appeal for reasons to be given in writing later. Thank you very much.
All rise.